Okay, so we are talking about compromises at the Constitutional Convention. And I said some of them were pretty specific, and I pointed you to a chart on page 32, 30, I'm not sure what page it is, it's 30-something, where there's a list of compromises. I said they were pretty specific and institutional. Then I said there are also a series of other compromises that were made that are harder to grab onto, just a little bit harder to grasp and to explain. Basically, there are 4 of these. The first, we said something about just a moment ago, separation of powers and checks and balances. That's the first one. We always put separation of powers and checks and balances together. Separation of powers means simply the founders sat down and said, now what's a government supposed to do? And they came to the following conclusion. Governments have to make laws, legislate, implement laws, enforce laws, execute, executive, and in case there's a law or a problem, someone has to figure it all out, judicial. So the theory of separation of powers, then, is that I separate and identify the powers of each branch of government, but you give each branch of government just a bit of the power of the other 2 branches, so that that one branch can be a check or balance the power of the other. Congress declares war. The President asks Congress to declare war. The President appoints justices to the federal courts. The Congress, the Senate in particular, has to confirm. All money bills must originate in the House of Representatives. Why? Because the House of Representatives is broadly elected, whereas the Senate, at the time of the founding, was elected indirectly by the state legislatures. So do you get the idea? I don't want to beat this to death, but rather simply go through it in a kind of simplified way that will give you a framework for doing your readings on this. It's really very simple. Divide up the powers, specify who can do what, and in that specification ensure that each branch retains enough of its own power to counterbalance the power of the other branches. Thereby, it is impossible to centralize power in a particular system, and you can avoid the difficulties of having a king or a monarchy, and so on. That's the simple power. So that first compromise then, we call separation of powers and checks and balances. The second is much more complicated and is going to take us further afield, and it's going to take a while to come down to it. Federalism. This would be the second compromise. Federalism. Now, just what is federalism? The theory of federalism, like checks and balances, is very, very simple. The devil, as we say, is in the details. Basically, federalism says that the entire range of government powers shall be divided up, and a national government shall have certain powers, and state governments should have certain powers. Remember, the main issue was, what is the proper relationship between states and the national government? The Articles of Confederation, bad, simply didn't work. Too much power to the states. Well, clearly there needed to be more centralization of power. But how much? And how much is enough? Checks and balances helps, obviously, but still you need to go a little bit further. and declare certain areas in which the national government will have authority, not power, authority, and the states will have authority, again, not power, but authority. That is federalism in a nutshell. Thus, you can say we have national power, state power, and then because the way the world is the way it is, we have something called concurrent power, where both state and nation, perforce, must cooperate in order to get certain kinds of things done. So if we're going to study federalism, and this is our first whack at it, our first bite of the apple, probably that's not the best metaphor, but I'm going to stick with it anyway. The first bite of the apple is that we take a look at, if we're going to study federalism, we are really studying the relative weight and the mix of national, state, and concurrent powers. Our entire political process can be viewed as one long battle over what is the proper mix, the proper mix of concurrent, national, and state power. See, I just said power when I should have said authority. It's a function of age, that's all. Authority. And there are several models which are spoken of in your text, and I'd just like to talk us through some of them. Beginning in 1798 and lasting through until 1937, we have something called dual federalism, which amounts to the following: that the states do certain things, and the nation does certain things, and there's very little contact or interaction between the two. In 1819, the Supreme Court established that the federal government, the national government, had a right to establish a national bank, and that states couldn't sue the national bank, couldn't tax the national bank. Well, that was it. National power, national authority, state, and there it was, clear and distinct. Later on, in 1857, there was a case before it went before the Supreme Court known as the Dred Scott case, Dred Scott versus Sanford. It was in 1857, I think. Basically, the Supreme Court held that the national government did not have the power to declare an area that was not yet a state, but was a territory, to be free from slavery. In other words, the national government could not ban slavery in new states. That was a big boost for state power, and is an example of what we call dual federalism. Just to make it whimsical, our authors refer to this as layer cake federalism, where you have the two sides, and one layer, the other layer, each does its own thing. A second model is something we call cooperative federalism, and our authors, in their whimsical way, refer to this as marble cake federalism, which exists from 1937 essentially to the present. What this simply says is that there is interaction between the different levels. State personnel interact with national personnel, and there is coordination, there is back and forth, there is manipulation in the good sense. There's an attempt to work things out. So we have cooperative federalism in the marble cake variety. Again, in 1937, we come to yet a third model, which we refer to as fiscal federalism. Fiscal federalism is very much dominated by the national government. In the simplest terms, fiscal federalism refers to a version of federalism in which the national government makes available to the states certain grants of money. These grants are given for specific kinds, specific categories of behavior, ranging in specificity. Education, there's a categorical grant. Special education, there's a categorical grant within a categorical grant. Access to buildings, the building of ramps. So there's a special within a special within a special. Fiscal federalism probably represents the peak of national influence in the federal, in the operation of federalism. Remember we said that there's state authority, national authority, and concurrent? In fiscal federalism, that national authority is primary, and that is because it provides money to the states to spend, and most importantly, specifies the exact ways in which it has to be spent. Sometimes we chafe at having to turn in our attendance reports all the time. You chafe because you feel you don't have to do it. I chafe because I think it's beneath my dignity to do it. But the fact of the matter is, we operate under a categorical grant. And if we can't demonstrate that we are fulfilling the requirements of that category, then the college doesn't get paid. So that's why we do it. That is the nearest, the best example that I can give of a categorical grant. That said, I think the whole thing should be abolished. It's a waste of time and money, and you may report me on that if you like. So, categorical. And then in the 1960s, we moved into something that I personally don't think ever existed, but your authors say that it did. And so I feel compelled to mention it. This is called picket fence federalism, which holds simply that the way to slice the authority pie is not nation, state, but rather its function, education, road building, public health, and that there are people at the national level who work that way, at the state level who work that way, and so on. And so what you do is, together, it's a kind of cooperative federalism, people with similar areas of expertise and functionality come together and make proposals, and then they are either supported by the Congress in budget terms, or they are not. Picket fence. In 1969, things began to change, and we entered a period of what was called New Federalism. New Federalism really began in 1960, and it continued into the 1980s, largely under the sponsorship and support of President Ronald Reagan. And it was a reaction against the fiscal federalism that had existed before. The major difference between the two was that whereas under fiscal federalism, money was given for categorical The grants were categorical, had to be spent a certain way, specified. Under the new federalism, categorical grants were converted to block grants for the states to use in any way that they saw fit. And then we talk about something called coercive federalism, which doesn't really exist very much anymore. But there was a time in the 1970s and 1980s when the national government would simply use its authority to say, states will do X, Y, and Z. And these were called unfunded mandates. In other words, you have to do something, but the way you do it is entirely up to you, but it just has to be done. Otherwise, you will pay a particular difficulty. This was the period of great regulation, and this was the period of federal government threatening to withdraw funding from various kinds of state projects. So, we have looked at 6 models or ideas of federalism. Now, over 200 plus years, 6 models of federalism, I would suggest that suggests a certain amount of evolution and change. And indeed, if you look at some of the dates, 1937, 1937, 1937, 1961, 1969, the 1970s to the present. 1937 marked the 5th year of the worst economic depression our country has ever seen. It was a world depression. The government was the national government, as the only source that had any money at all, any public goods at all to share or to allocate, began to do more and more and more. As they did more, it pleased some people, it displeased other people. Those whom it pleased argued for more and more. Those whom it displeased argued for less and less. They engaged in a struggle, a process for the authoritative allocation of values. They engaged in a process of competition for public goods. We engaged in a process designed to determine who's going to get what, when, where, and how. Okay? That political decision, that political process, was influenced by the federal structure that existed at the time. At the same time, that process changed the nature of the federal system by which it existed. That's the principle I would like you to see. The details are very important, and we can fill them in as we go. But it's essential that you see what is going on right now in Washington, D.C. If you like, with medical care reform, is related to the nature of our federal system. And I hope that you can make that connection. Okay, so we've talked about some general compromises. We said there was separation of powers and checks and balances. We said there was federalism. The third concept, which is never really expressed anywhere specifically, involves limited government. All sides agreed that government would be limited. Now, what does the 10th Amendment to the Constitution say? I think it says that every power not specifically delegated to enumerated to the national government is reserved for the states. I would suggest to you that that is an example of an institutional expression of the desire for limited government. So, 3 compromises so far came out of this. The 4th, which is very important, did not come out of the Constitutional Convention. but rather evolved over a period of time. This is the concept of judicial review. That is the notion that the Supreme Court can declare, if it feels to be so, that an act of the President, that an act of the legislature, that any action of government is not consistent with the principles of the Constitution and therefore unconstitutional and illegal. The big case here is something called Marbury versus Madison. And I want to save that, a more detailed discussion of that, for our discussion of the judiciary. Basically, what Marbury versus Madison, in the case Marbury versus Madison, Marbury asks the court to order the president to do something. The Chief Justice of the court said, the law that gives us that power is not a constitutional law. We can't do it, and we're not going to do it. So then, keep in mind, 4 basic constitutional principles that come out of all of this. 1 is separation of powers and checks and balances. 2, federalism. 3, limited government. And 4, judicial review. Thanks. I'll see you next time.